Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Today our topic is going to be divorce and family law with the new law. Welcome, Jesse Barrientos, my co-host. How you doing, Jesse?
Great, Dave. I'm doing great. How about yourself?
I'm doing well. It's great to have you as always, but especially today because there's been significant changes to divorce and family law beginning January 1st, 2016. Is that correct?
That's correct. They completely revamped the Illinois Marriage and Dissolution of Marriage Act.
Well, my first question is why? Things were going sort of well, correct?
Well, everybody, people in the legislature try to get input from the attorneys who practice family law, and to try to make things better. There were some areas where things weren't codified, they weren't actually put in the statute, and then depending upon the judge or jurisdiction, they would do different things.
So with everything going on with the financial crisis in the state and the budget and the gridlock, they somehow found time to redo all of the divorce laws, which effectively changed what we call certain things, which you'll get into.
Right.
They found time for that. That was a need that needed to be corrected, but the gridlock and the budget and everything and didn't need to be addressed. Is that what you're getting at?
Well, I think at some point everything kind of needs to be addressed. But the deal here is some people like it, even judges, attorneys. Some people don't. There are some people like part of it and don't like the rest of it. It's a new thing for everybody. Everybody's in the same place. I remember at a seminar sort of last year when the legislation we knew was going to kick into effect, and the speaker mentioned something like, "Okay, anybody under 40, or 40 or above, time to retire." Not really. It was just kind of letting us know, look here, hey, there's going to be changes for everybody to address.
Yeah. Well, look, everything got turned on its head.
Yep.
Everything that you knew as an attorney started to change a little bit with the new law.
Correct.
And we're going to talk about a couple or several of those different things and how it affects people and whatnot. But I want to start with the first one, which is, to me, kind of the most obvious that most people know about.
Sure.
And that's grounds for divorce. They've heard about grounds their whole life. The cheating spouse, the
adultery, yep.
abusive spouse, whether it be physical or
cruelty.
mental, the spouse that deserted and that went away, all these things that everyone has known their whole life, which are valid reasons to want to separate from someone that you have a contract with. But what did the legislature effectively do with all of those grounds that I just mentioned, except the one I haven't mentioned?
Well, the one was irreconcilable differences, but back in the old statute, you had to live separate and apart for a continuous period in excess of 2 years. Now, most of that, everything except for 6 months, could be waived by affidavit. But the way it is now is there are no grounds other than the no-fault grounds, which is irreconcilable differences, and you just have to have lived separate and apart for a continuous period of time in excess of 6 months. Now, it could mean a lot of different things.
So wait a minute. So your spouse can be cheating on you, coming home and beating you, publicly embarrassing you, making you go to a therapist because of the mental abuse, but yet if all that happens within 6 months, you still can't file yet. Is that what you're saying?
Oh, no, you could file. You certainly can file.
You can't get it done, though.
Well, you might be able to get it done because the difference, the kind of definition of living separate and apart doesn't necessarily mean physically living separate and apart. Sometimes people will live in the same house. Somebody will go to another room. Wait, let me finish. Or sometimes they won't even, they'll sleep in the same bed together, but they're no longer intimate. They're no longer living as husband and wife. So it's when when the marriage really first started to break down, and 6 months really isn't a long time. When you were talking about if somebody's beating you, well then, hey, that's a criminal matter too. You need to call the police immediately. Call 911 if your spouse has beat you, and you can get order of protection. There are other remedies for that.
But if he comes home on New Year's Eve and smacks you around, and you call your family and your friends the next day and they say, you know what, leave him. You file on January 1st or January 2nd, the court's closed January 1st. You're technically not eligible for a dissolution judgment, a finality, until July 1st of that year, correct?
If the marriage didn't fall apart before then, and this was the first thing, and that was it. But it doesn't matter because,
No, it fell apart in a snap. He went out New Year's Eve, he came back swinging.
Dave,
that night.
First he'd be in jail, and she'd probably have exclusive possession and everything else of the house under the order of protection laws, domestic violence as well. He'd probably have his problem, he's a criminal problem as well, and he might be doing some jail time depending upon the unique situation of the circumstances. However, 6 months really isn't a long time, because when you do any type of litigation, especially divorce litigation, and it depends whether or not there's a lot of assets and a lot of debt or not. But just to get through everything, it's going to take a while, because you're going to go through the discovery. The discovery is going to take you probably 60, 90 days. You're going to have other motions for temporary maintenance and support and for other things. That's going to be another 60, 90 days. So realistically, that 6 months really isn't going to matter.
We're just going to have to disagree on that, because 6 months is a long time. Get yourself locked up for 6 months, and then you tell me that wasn't a long time. Report back to me on that one.
I'm a law-abiding citizen, Dave. I hope that never happens.
It's a long time.
Yeah.
Trust me, 180
Sure.
days. But so the grounds are gone. And explain to the viewers the reason why the legislature wanted to leave irreconcilable differences as the only ground, and they got rid of all the other grounds that were a little bit more difficult to prove and
Right.
difficult in general on people.
Before, the reason why somebody would, in the petition for dissolution, they would allege both the grounds that we no longer have, which is mental and physical cruelty or whatever else it was, and then in the alternative, irreconcilable differences. Because again, under their own law, you have to be 2 years living separate and apart, but you can waive all of it except for 6 months. But that's in case the other person said, no, I'm going to wait here. I'm not going to sign the affidavit, so you got to wait 2 years. No. So you could do it under the other grounds pretty much kind of immediately. You didn't need to rely on that. But the thought of the legislature is, hey, look, people are going through a difficult time and everything else. There's no reason to assess fault or blame. There's nothing quite like it's the death of a marriage. It's the death of a relationship. And so there's no reason to really to pin fault on anything, because it really doesn't matter. It doesn't matter if somebody committed adultery. Okay, hey, somebody did something, all right, that wasn't appropriate, but it's not really going to make a big difference in terms of any of the equitable division in the divorce. So the thought is, why are we assigning fault to all this and and taking up some time? Well, let's just get it done. And so that's the universal ground.
Well, I think we're sugarcoating the grounds, because sometimes there actually is fault, and someone is a good spouse, and someone else is not a good spouse.
But it doesn't matter, Dave, for purposes of a divorce.
It doesn't matter for
Right.
purposes of division of property. It will come into play with the children,
It might,
possibly.
right.
But that's a major change.
Sure it is.
We have one ground now.
Right.
Irreconcilable difference, that's it.
That's
Forget
correct.
adultery, forget mental cruelty, forget habitual drunkenness, physical cruelty, desertion, forget it. The only thing that our viewers need to worry about or be aware of are irreconcilable differences, correct?
That's right.
Okay, that's a big difference. Let's go into the second big difference. And I'll leave it up to you, because there's a couple that you can choose here.
There's a lot of different things I can talk about, and if we have time,
Name
we'll
them.
talk about it. Well, let's talk about, in terms of major people are thinking about custody
Yes.
and visitation, which those terms are going to be around for years and years and years to come, because that's what everybody is used to. And what they've changed it now in name, it's no longer custody and visitation. It's the allocation of parental rights and responsibilities, and it's broken up into two different prongs.
Wait, time out. No
Yep.
more custody?
Well, there kind of is, but
Yeah.
you'll see. I mean,
I'm playing the devil's
we could say,
advocate. This is what you're gonna
You play a
hear.
good devil, Dave.
Yeah, you bet. I got practice.
Yeah.
You're going to hear about this question for your lifetime and probably the next generation of attorneys'
Oh, sure.
lifetimes, because we're all programmed to know about custody and children.
Right.
Custody and children. Visitation, children.
Right.
Child support, children. These are terms that have become mainstream all over the country, for that matter. So Illinois has decided to do away with the word custody.
Well, let's call a rose is a rose by any other name, right?
Right.
And so,
What's the thinking, though? I want a background on the thinking, and then we'll explain how it's going to actually play out in reality.
well, the thinking is this: and I'm also a guardian ad litem and a divorce mediator, and for the longest time, even before the change in the law, we have kind of softened. Because custody and visitation are almost like ultimate terms. An ultimate term is a term that somebody uses that invokes great emotion. For example, America, and we talk about these horrible things that are happening. Those invoke tremendous emotions. And so when we talk about custody and visitation, and hey, I lost custody or visitation of my child, I lost all my rights, and they're really trying to get away from that, because realistically, the terms don't adequately really express the situation in terms of how things pan out. Now, with the allocation of parental rights and responsibility, broken into two prongs, one is decision-making and the other is parenting time. Decision-making and parenting time, obviously the parenting time is going toward what was formerly custody. And the decision-making is just that. And so in the decision-making, by the way, it has to be completed, allocation judgment, within 120 days after service of the petition for dissolution of marriage. A lot of judges in all the counties, and it depends upon the county, of course, but I mean, that is the law, and they're really, really pushing. And so if after the first status date, because depending upon some of the counties, you get a status date in 90 days. Okay, that's 90 days. You're almost there to your 120. And so if you don't have an agreement and there's not something in the works, the judge is going to appoint a guardian ad litem, somebody like me, an attorney who's going to do an investigation, make a recommendation so that they can meet that deadline. And that's going to cost the parties some additional funds because both parties are going to be responsible for that. But the decision making is religion, education, extracurricular activities, and medical, which is pretty much the kinds of things that everybody else has. Obviously, medical decisions, if it's an emergency, not. But what can happen? Before we had joint and sole custody, before, if you had joint custody, it meant that both parties, the non-custodial parent, had a say-so in all those decisions. In sole custody, only one parent, the custodial parent who had physical possession of the minor children, could make all those decisions. And now, all of those 4 different areas can be divided. So realistically, you could have a sort of a joint custody if both parents are going to equally share in those decisions, then they can. Or it could be maybe one person is going to be responsible for 2 areas, the other for a couple areas, or maybe one person is just going to be exclusively responsible for all the areas. And the reason before with joint custody, it was only awarded by agreement because the court couldn't do it, and it was only for people who were able to cooperate when it came down to the children. Now, a lot of people can't cooperate, and so that's why I said call a rose, rose is still a rose by any other name. So if realistically one parent is allocated all the decision-making authority for all those areas, I mean, what do we call that then, Dave, really?
It's sole custody.
Right.
And sole decision making.
And if both parents are allocated equal decision-making in those areas, then what would we might call that, Dave?
Equal?
Right.
Joint custody.
Right. I mean, so
Yeah, but here's
so you have to look at the
But
difference.
here's the thing that I see with this new law, and
Sure.
tell me if I'm wrong here. We took a fairly complex agreement, whether it was joint custody or sole custody.
Well, it's more complex now.
Right, and we magnified it so many times that I think it's going to open the door to a lot of post-decree litigation by one party saying, hey, they're not honoring, my ex-spouse is not honoring this custodial or apportionment order, allocation order to the letter, because now there are so many more letters, so many more clauses, so many more prongs, where before it was a little bit difficult, but not to this extent. This is crazy.
Well, here's the thing. Before you could certainly do it. If somebody wasn't doing what they're supposed to, you could file a petition for rule, which is the way that you get somebody to, who hasn't complied with an order to comply with it. It's the same here, too. The bottom line is that there's no agreement that's going to cover each and every situation and events that could occur. But, what's happening, and it depends on who's drafting the allocation judgment. Some people draft it, I mean, there's some things that absolutely have to be in there, but some people draft it in more detail, some people don't. I'm one of those who believe in the detail, and the reason for that is, hey, look, because sometimes people just want to, I just want to look, what am I required to do, and here's the agreement, and I could see that. And that's not a good thing either, because it should be kind of a growing thing. And in all those agreements, you can, and they're trying to take out having to do post-decree. Because if we have an agreement, Dave, I don't have to march into court. If we have it in writing, and I'll tell you about that after you make your comment. Okay. We could talk about it's not removal anymore; it's relocation.
We'll the agreement's important, though, and I want to bring this up too. There is no court-approved or state-approved model agreement that people can use. Correct? In other words, you have the ability to draft the agreement you want,
right,
as does another law firm,
sure,
as does another law firm. So you're going to have a hodgepodge of thousands over a course of several years, potential allocation agreements. Is that correct?
That's correct, but there are certain, and we call that generally boilerplate, there are certain terms that have to appear in every one of those agreements. And the judges, because the laws change, okay, the judges are reading, they're going through the agreement. They want to know.
Right, but my concern is that the parties, the actual litigants, are not going to read that agreement when it's the length of the Bible.
Well, but and I don't know how anybody else does it. I go through it with my client completely, so that there's no question about it. I explain in terms of the new law, similar to what we've done here, but maybe in a little more detail because, of course, we have more time. And we go through the things that are important to them. A lot of the other stuff, the boilerplate, that's not important, but that, what does this mean? And so we go through it and understand, this is what it is. And so if an attorney hasn't gone through through it with their client, there may be an issue because, look,
Absolutely.
I send it to you and I ask you for, and I want it in writing and I want an email that you're in agreement. And then if you have questions, we'll deal with it.
Jesse, I'm talking about the law of unintended consequences,
Right.
where the legislature thinks that they're doing something positive, and in reality, the clients aren't reading the entire agreement. They're not understanding the agreement. For you to send a draft to another attorney and back and forth, for you and he or her to make sure that there was nothing thrown in and that everything is perfect for the negotiation is going to be an arduous task. And you're going to really have to do a lot of hours of work to make sure that everything is exactly as agreed upon. So there's a malpractice issue to this as well. That's my concern.
Well, Dave, first, the United States of America is a nation of laws. And there's more and more laws all of the time on all different kinds of things, maybe even handheld cameras someplace, okay? But I will tell you this, that the same thing existed before. And you need to be detailed. Again, I don't know what other attorneys do. I send it to my client and give them time to review it. I don't want them to get back to me in a half an hour, an hour. I want them to take a week, take the weekend, as much time as they need to go through it. And if they have any questions about anything, then we can explain them. If they have any proposed changes they want to make, they give me the basic agreement. This is what what I would like to do, or
Okay.
if the parties have an agreement, and then we go back and forth with the other
I get it.
attorneys.
I'm not making 100% sense to you, I can tell. But let me give you an example that
Sure.
might make sense. You go to a diner and you order a burger and you order fries and you order a milkshake. Pretty simple, right?
If it's not a la carte.
That's almost what the old divorce was compared to the new divorce. Because now the new divorce, you're ordering the hamburger. You want it done a certain way. You want 6 different condiments on it. You want your fries cooked a certain way. You don't want them how they produce them. You want them well done. And you want that milkshake with a special kind of milk, a special kind of cherry, and you don't want it too rich, not too much sugar, maybe the substitute. You see my point? They've complicated something that 50% of married couples have to go through, and they've complicated it to the point where it's going to cost everyone a lot more money. There's going to be agreements where they don't know what's in it because it's the size of a small novel. I just don't think the government has done right by the people in Illinois.
Well, let me address first. When I go out to fine dining, I don't know what burger is fine dining, but certainly I want the meat cooked the way I like it cooked, medium rare. I want certain condiments on there. You might want jalapenos or not, but maybe sometimes I might want that.
Yeah.
You know what? I might want a little extra vanilla in my shake. Okay,
Let me see you order your next quarter pounder the way you
Oh,
want.
I don't.
Okay?
Well, I don't go to that other place where you get quarter pounders, but very often. But
You get my point
I
now.
get your point. The bottom line is, is it going to be more difficult and expensive? It may or may not be. But truth be told, because we have this 120-day deadline, a lot of attorneys are really coming together, and that parent, because that's what's most important, is what's going to happen with the kids. In any litigation, once you have that taken care of, once you have the parenting time and you have the decision making taken care of, the rest of it most likely kind of falls into place, because that's the toughest sell there in terms of what's going to happen. And so the deal, though, where it can come into an issue is it can be like a mini custody trial if it's got to be done within 120 days. And there are some judges that will do, okay, guess what? And they have pretty decent forms for their judgment covering all of those aspects, all the elements that have to be in there. And if the parties aren't in agreement, you're going to have your hearing for an hour or however long it is, and then he's going to make a decision. Now, a lot of judges will have no problem entering a temporary allocation judgment. But that kind of defeats the purpose. And the whole point and intention, I believe, of the legislature was to make it easier to get this done. And again, realistically, a lot of those judgments are getting done within that time, which wouldn't happen before.
Okay, I see your point.
Yep.
One other thing before we move on is I have to
Sure.
quote an attorney who used to work for me, and he used to tell me that the court system is ill-equipped to handle the social needs of the parties in a divorce. And he's really right on that. And I think it's gotten worse. A lot of the information, by the way, that we're talking about was produced in an ICL. Can you explain what an ICL is for the viewers?
Illinois Continuing Legal Education. It's a publisher that has well, any type of area of the law, they have information, in-depth information, and it's really important for practitioners to get their information from, different sources. Obviously, hey, because there was a change in the law and the whole statute was revamped, we need to know not only what the new statute is, but to see exactly what those changes are. So there's a lot of things that have kind of remained the same in terms of factors that have to be considered by the courts and making determinations and everything else. But there have been a lot of other additional variables that have been added to that.
In the ICL that I'm referring to, the current one is written by Steve Peskind, and this is the ICL right here on the 2015 edition, and then he did a revision of the changes to the Illinois Marriage and Dissolution of Marriage Act. They called it an overhaul, so it is significant. I just want to show the viewers here what's contained in this ICL. I mean, it's totally voluminous. There's a lot to it.
Well, I can show you mine, Dave. Here's the smaller version. It's just smaller print. That's all.
Okay.
But it's a lot.
Well,
it's a lot of stuff. They revamped the whole statute.
I've beat up the law a lot now, but let's get into some of these specific changes that people do need to be aware of, ones that we have not covered yet.
Well, let me take, because I'm not sure how much time we have left, so let me take care of one that's going to be, that's important, and that is removal. It's no longer called removal. And again, here's a change. It used to be
Explain
called
what
removal. Now it's relocation. Removal was you had your agreement. Now you're divorced. I'm getting parenting time, and which was formerly visitation, and now one parent, the custodial parent. And by the way, in our new law, they have a clause that's in there that gives one parent, in name only, they name him as the custodial parent, and that's for the school law, for purposes of being able to register your child in that. But it also goes on to say that just because it's a name only, it does not, prejudice the other party because this person has custodial. So that's for the reason for that. But we're talking about now relocation, formerly removal, where now the person who had physical possession of the children would want to move to a different state. Maybe they remarried, maybe there's a better job, and so what would happen if there's no agreement, they would have to file a petition for removal. But the new law states that relocation is, again, formerly removal, is within 25 miles of where you're at, because before you could live, let's just say, in Wheaton, and the other person could move to the Quad Cities, just not quite over the border, or to Peoria, which is a long way away, and there you go. They didn't need to file a petition. Obviously, something would have had to have been filed for formerly visitation, or now parenting time, but now it's within a 25-mile radius. However, the legislature did provide a way to possibly save some money. So there's a whole scheme that's listed in the new statute, where the parent who wants to do the relocation, again, we're talking within a 25-mile radius. If there's an agreement, fine, no problem. The parties can agree on it, and you're good. But what has to happen is the person who wants to relocate has to file a notice of the relocation, and they have to file it with the clerk and serve it on the other party. And they have a certain amount of time within which to respond. And if there's no response within that time, then they're free to move. But if they do respond and they do agree, that's great. That can be filed with the court. You're done. You don't need any attorneys. However, if there is an agreement and they file that and they're not in agreement with the relocation, then obviously there's going to be a court hearing on that. Then you have to file a petition. So it's kind of designed, and thinking behind that was to try to save some money, but also within a 25-mile radius is pretty good, because how would you like to have an issue where now you have to go to Peoria or some other place when you're here in Wheaton or some place like that, with that great distance?
I could just picture a vindictive spouse moving 24.5 miles away.
I could see that. I could see that too.
To make Papa drive so far to see little Johnny. I could just see that happen, or vice versa.
Well, a lot of people are, unfortunately, people use their children as pawns to get back at the other person. And really, look, if you're getting a divorce, or you are divorced, you had a problem with your spouse. Okay, you had a problem with your spouse. All right, you should talk. And actually, there's language in the agreements about that too. You need to not talk in a derogatory manner about the other spouse. I don't care. It doesn't matter how you feel. All right, that's your child. You don't want to kind of what they call kind of alienate them. You don't want to plant things in his or her head. Really, everything that you do should always be about the best interest of that child. And as a mediator, you tell people, okay, you love your kids? Oh, sure, yeah, they love them. You do anything to for your kids, even though it might be inconvenient? Yeah, okay, all right. Now we get to this issue about driving. Well, it's going to take me, an hour in traffic to get over there. I'm not going to. Well, wait a minute. You just said you would make yourself, you would be inconvenienced if it's in the best interest of your child. Okay, so again, that's really important. So
What if the 25 miles doesn't cross the state or does cross the state line?
it's within 25 miles. You're fine.
Okay.
Right.
So someone who's in
from where you're at.
Waukegan, Illinois,
Right.
can move to Kenosha without court approval because that's within 25 miles.
Yeah, I believe that's correct. However, it does say in the allocation judgment that, and the UCC JEA, Uniform Child Custody Jurisdiction and Enforcement Act, all right, and again, that's the reason why we have these extra provisions, which, of course, it makes the agreement bigger. But it says, and that was part of the issues they were trying to get rid of, that Illinois is the home state of that child. And you have to litigate everything not only in the state of Illinois, but in that district court or whichever the local or county you were at.
Okay, we just have a couple minutes left, so give us a couple more quick highlights on the new law.
Okay, well, probably one of the best ones I could come up with here is the court has the authority to appoint financial professionals and other people that they deem fit. So in other words, if you have people coming in, there's a problem with dissipation, somebody using money, marital money, for a non-marital purpose, the court can appoint an accountant or anybody that they want to basically just say, for example, take in all of the money of the people and pay all of the bills and give them a stipend and everything else so as to preserve the marital estate. The
Who pays for that? How is that
of course,
allocated?
it comes out of the marital estate. The parties. It could come off the top. It depends on the situation. The judge can do it either way. If the reason why we have to do that is because you're dissipating assets, well, it might come out of your portion. It just depends on the specific circumstances of the case. They can also, a court can appoint a parental coordinator, which people are having issues, right? Like you said, they're vindictive and everything else. And so they can have somebody that they work with to make sure things go smoothly because, again, it's all about the best interest of the children, as it should be.
Parenting class still in play?
Yes, still have to take the parenting class.
Okay, it hasn't been increased to like a graduate level degree, or are we still at just the
We're still
minor?
at the parenting class. And it's basically, it gives, from the response I've heard, some people think of it as a hoop they have to jump through, but really, it really tells people about what happens when a child or children go through the divorce process and what to look for. So, it's educational and it's required in every county.
Okay, so it sounds like in general you have a positive outlook on the new law going forward.
Dave, look, I work within the system. This is what the wise men in the legislature have, and it's also...
Well, they can be voted out.
But they have had input from our bar association,
They
too.
work for you and me.
Well, they do, but and everybody else. They've had input from our local bar, too, and nothing is perfect, and you can expect a whole bunch of tweaks, like when you get the first version of, I don't want to say it, but you know what I mean, of any electronic thing, it has to work the bugs out, or any app. And so that's what's going to be happening. The bugs are going to be worked out and it's going to be refined. So hopefully in the next several years here, we'll see that tightening up the belt a little bit.
Okay, so just to recap, the three big takeaways that I see is the grounds have changed, simply irreconcilable differences, being apart 6 months, that's required. Custody is gone, that's now allocation, and visitation is gone, that's now parenting time, correct? One word answer.
Correct.
Okay, we'll see you next time on Legal Action. Thanks for joining us. Take care. Bye-bye.